Clegg. I'm a solicitor and head of private client and family at Douglas Wemyss Solicitors. Today I'd like to talk to you about prenuptial agreements. Interest in prenuptial agreements, or prenups, is increasing, especially following the recent well-publicised case of Radmacher and Granatino. The current position is that they're not a binding contract, such as to take matters out of the hands of the court completely, but they are increasingly taken into account by the courts in making decisions on matrimonial finances. The court is required to take into account all the circumstances of the case, and the existence of a prenup is likely to be one of the most important circumstances. The court is also required to consider issues of fairness, and it may well be unfair to disregard the prenup. The court is more likely to depart from the terms of the prenup if there have been major changes which have not been provided for, such as the birth of children, or if the effect of the agreement might be such as to leave one party dependent on state benefits. One of the judges in Radmacher suggested certain questions should be asked. In summary, these are: did the parties intend it to have legal effect? Were there any circumstances which would, under the general law, invalidate a contract? Was there anything to suggest that one party was taking unfair advantage of the other? The case of Radmacher and Granatino was reported in some quarters as a landmark decision which made prenups binding. This is not quite correct, but the court decided, in the circumstances of that case, to follow most of the terms of the prenup, even though it was not very advantageous to the husband. And they thought there was no reason why a court should not follow the terms of an agreement which had been freely entered into. In another case called McLeod, the agreement was signed on the day of the marriage, which would normally make it almost certainly unacceptable. But after the marriage, the parties twice agreed amendments. The court said that prenups which were updated during the course of the marriage, such as to reflect changes in circumstances, stand a good chance of being accepted. The present position, in summary, is that prenups are not binding on the court, but the court, in exercising its powers, will attach considerable importance to a prenup which has been properly entered into. Many other countries now recognise prenups as fully binding, and it seems likely that England will eventually follow suit. The issue is currently being considered by the Law Commission. In the meantime, your solicitor can advise on the position and on any proposed agreement. Thank you very much for listening.